Welcome and aloha. I am Mark Shklov, host of ThinkTech Hawaii's Law Across the Sea program. Today we're going to cross the sea and then across the country to the state of Georgia to meet Clayton Cartwright, a lawyer who practices, among other things, international tax law in Columbus, Georgia. I met Clayton through email discussions with a bunch of lawyer friends, and we were talking about international legal issues, including a lot of immigration law. During our discussions, Clayton brought up two very interesting topics that I frankly were new to me. But they interweave tax law and immigration law. Those topics are the topics of our program: accidental Americans and taxigration. I've discovered that many lawyers don't know what those topics mean. And so I asked Clayton to come on today and help us to define those topics and tell us what they are. So welcome, Clayton. It's good to see you. Aloha, as we say. I really like your shirt, by the way.
Aloha. It's vintage Hilo Hattie from my last trip to the islands, which was way too long ago.
All right. Well, we're looking forward to seeing you again soon. I understand you may be coming back, so that'd be great. Yeah. And looking forward to that. Now, these terms came up in our discussion: accidental Americans and taxigration, and I asked you to define and explain these terms. So let's start with basic definitions. And what, where, how, who are accidental Americans?
Sure. And so this all goes back to really the U.S. and the 14th Amendment to our Constitution. And anyone who follows U.S. politics pretty much knows that anyone who's born on U.S. soil, with very limited exceptions, is a U.S. citizen. But that's not the norm internationally. And so the idea and the concept of accidental Americans comes into play when somebody is briefly in the United States, whether intentionally or not, in terms of having a child, has a child in the States, and U.S. citizenship is conferred on the child by application of the 14th Amendment to the Constitution. And so that's all fine, well, and good. And generally, when an individual learns of that citizenship, they're very happy. But then they realize the tax implications that come with it. And that's another aspect of U.S. law that differs from international norms. And that's the fact that U.S. tax law taxes individuals, U.S. citizens, on their worldwide income, no matter where in the world they live. Now, that may make sense to a U.S. audience. I'm a U.S. citizen. Everyone pretty much in the United States knows what a Form 1040 is. They file the 1040. Doesn't matter where in the world they live, they have to file the 1040. However, that is not the international norm. Worldwide taxation based upon citizenship is not the worldwide norm. Worldwide taxation based on residency only is the worldwide norm. And so this idea of accidental American comes into play when someone is, say, 18, 19, 20 years old and realizes, wait a minute, I was born in the United States. I'm a U.S. citizen. Hooray. Then they find out, oh, wait a minute, I'm a U.S. citizen. And ever since I was born, I've been subject to the U.S. tax system. And U.S. tax law takes its cue from U.S. immigration law. It's a very easy citation in the U.S. tax code to find where this links and where the taxation is imposed. It's Code Section 1. Section 1. The regulations under Section 1 back in the 1960s basically says, if you're a citizen under the Immigration and Nationality Act, you're a U.S. citizen for tax purposes. And so when I'm working on these issues, I'm a tax lawyer. I practice what I call immigration tax law, immigration-driven tax law. That's sort of what taxigration is. But when I hear that, I'm always relying upon the opinion of Immigration Counsel. Sometimes it's very easy. Sometimes it's not so easy because someone can be born abroad to a U.S. parent and have U.S. citizenship conferred upon them without anything that the person has done. And that goes back to a U.S. Supreme Court case back in the late 1970s that says that if you want to, you cannot give up or you cannot lose your U.S. citizenship unless you make an affirmative action to do so. It must be willful and voluntary in order to be able to lose that citizenship. So there's nothing, they have the citizenship. So again, it seems like a gift, and then it seems like a big burden when you look at the tax issues.
Well, okay. So you're born in the United States. You may not realize that you're a citizen of the United States, and you leave the country. You're not in the United States. What are the real life repercussions of being an accidental American with respect to taxes? Then what are the issues that you're facing?
Well, I mean, as soon as you find, I mean, if you're living ignorant bliss, and you never, even if you knew you were a citizen, okay, but you never knew about the U.S. tax issues, you're sort of living abroad. The accidental Americans living abroad in ignorant bliss here, but it's at the point of when they will know. And the issue has been over the last 10 years since something called the Foreign Account Tax Compliance Act, FATCA, FATCA. You know, DC loves an acronym, right? And so I spent 7 years in DC from 1990 to 1997. I'm filled with acronyms. Okay, FATCA is one of them. And so, and a lot of individuals abroad, U.S. people abroad, many U.S. persons abroad know what FATCA is. And as a result of that, the U.S. entered into approximately 100 information sharing agreements with other countries. Okay, and so what would happen is, and why the issue is being flushed out over the last 10 years, is a U.S. citizen abroad may have received a letter from their financial institution, say in Germany or in Switzerland, and it says, well, we're doing due diligence on your account here. If you're a U.S. person, please fill out this form W-9, which is a form that identifies them as a U.S. person. Most people, U.S. citizens who fill out a bank account, open a bank account, they know what a W-9 is. It's a half-page form. Or if you're not a U.S. person, fill out this form W-8 and identify yourself. And so now it's being flushed out here, and people are becoming more aware. Why am I filling out the form? And then they ask someone else, and then they talk to other people, and maybe they do a Google search. And then at some point in time, the ignorant bliss goes away, and they have reason to know that they're a U.S. citizen who has to file tax returns annually and declare their worldwide income.
Wow. So that could be a substantial monetary burden if they have to pay taxes, or at least they would have to find that out.
Yes, there's actually two aspects to it. One is true tax liability. And so, I mean, there are international rules, generally based international rules about giving tax credits and being able to not have to pay double tax. Okay, here that the income is sourced, and even if you're a tax resident in two countries, one country may claim primary jurisdiction over the income, and the other one will give a credit. Okay, so you end up paying the greater of the two and not double. The problem is that tax laws are not written on the same platform. Okay, it's not like, the way I've described it to clients, it's not like if I have an iPhone, but let's say you have an Android phone, okay, and if you have a Samsung phone and an LG, okay, they're pretty much going to run on the same software, okay, here, because they're both using Android software, same platform, everything else. Well, tax laws of countries are not really written on the same platforms here, and so there's a lot of incongruence between systems, okay, and so the U.S., for example, hates foreign mutual funds. They think they're an avenue for, they're often referred to as passive foreign investment companies, and the U.S. loves to punish those. The problem is that a tax regime that's been in place a very long time, for decades and decades, that was designed to punish the rich, has no de minimis rule. And so if you have one of these things that's worth $1,000 as opposed to $1 million, the tax compliance work could be the same. And so that builds into something else: fees. It's not just tax, it's fees. It's fees from guys like me who have to charge to make a living here, in order to advise clients to first and foremost be in compliance with the U.S. tax system, and then second, of course, to minimize the worldwide tax burden. Yeah, as a long, God bless his soul, a mentor of mine from the 1990s who passed away in 2011 said, Cartwright, your first job is to keep your client out of jail. And so we always focus on compliance first here, and then we look at planning second.
Okay, so I wanted to get that basic definition out there that, you know, where you could be an accidental American subject to U.S. tax law, and there's lots of repercussions. Now I want to talk about the other term, taxigration, and you first talked to me or mentioned that in conjunction with people who immigrants to the United States who come and work. How is taxigration related to that? Or
Sure. So taxigration is a term that it's really taken off in the last 10 years in the U.S. immigration bar. And so it's just a mashup of words. You know, we like to mash up, you know, couples names, and, you know, when we're looking at pop news. And now I guess the lawyers to be quote unquote cool, if we can be cool. You know, the first one was crimmigration, the combination of criminal and immigration law, and then taxigration. And the idea of that is really the coordination of U.S. tax law with U.S. immigration law here, and combining the two, usually with co-counseling here, to make sure the two systems mesh for the client. Now, most countries already have, as an aspect of their law, taxigration in place. In other words, an immigration lawyer in Singapore is going to be able to talk tax law to you, because the two systems are sort of melded together. It's not the case in the U.S. The U.S. has its separate immigration code, separate tax code. And so one really good example of this is for green card holders, lawful permanent residents. Under a lawful permanent resident could very well be living abroad. They could be resident in another country that allows them to be that causes them to be resident for tax purposes in that country as well. There could be a tax treaty that allows that person to be treated as non-resident for U.S. tax purposes. Be taxable, in that case, they're taxable on U.S. source income only, period. U.S. tax law allows that position to be taken, not a problem. Under U.S. immigration law, if one takes that position, one is presumed to have abandoned their green card, presumed to have abandoned their green card. And so the two systems don't operate on the functions of science and physics. It's law, okay? And I have to tell my clients, my oldest friend, we were in nursery together. He has a PhD in materials engineering. Brilliant guy, can run mental circles around me. I have to tell my friend John that you know, the law is not as much an art as it is a science, and so you can't expect the two systems to be congruent, and they're not in the case of the U.S. Now, in other countries, they're better designed, and immigration and tax are sort of melded together by operation of law in terms of the statutory framework. Not so much in the United States. And so when we look at these issues here, you've got the immigration system moving in one way and the tax system moving in the other. And it's the idea here for somebody like myself to be able to work with immigration counsel, sort of bring everything in to optimize the results for a client.
And so there could be a conflict between those two laws, and you have to figure out where you are.
Yeah,
I guess is what you're saying.
Yeah, and it's not just the United States. I mean, I've moderated panels and spoken on panels for the International Bar Association, the International Association of Lawyers here as well. I'm members of those here. Chair actually the vice president of the Immigration Commission of the UIA, which is the French translation of the International Association of Lawyers, on coordination issues between tax and immigration. It's a topic that pops up every 2 or 3 years. It's a hot topic here because when those issues pop up, it could be disaster for the client. Gone are the days, Mark, and it's really for any aspect of law, it's gone are the days of advising in a silo. If there's anything the audience should take from this, particularly lawyers, is that it is not best practices in 2021 to advise in a silo and say, I only do this. Don't bother me. Go find an accountant. And I hear that a lot from some of my colleagues who are immigration lawyers. They're good people here, but it's not the standard of care anymore. The standard of care is coordinated advice.
Okay, so that sounds like good advice, and we've covered. I mean, although we've covered the basic definitions, I can tell there's lots more to talk about, just basically. But now we're going to skip ahead a little bit.
Okay.
I talked to some of my Hawaii lawyer friends who are very involved in international law, and they sent me some questions to ask you. So let's start with Alan Fujimoto. Asks, what is your advice if you're not sure if you are an accidental American? For example, he says, what if your father is a US citizen, your mother is a Japanese citizen, you were born and lived in Japan your whole life, and you have a successful career living and working and paying taxes in Japan, but you want to come to the United States under your Japanese passport? Is there anything to watch out for? What should you do in advance to determine if you're going to be subject to US tax law as an accidental American?
Sure. And, it's interesting. You mentioned the word advice, and I'll have to give my quick caveat here. I had the privilege of taking tax from the famous Marty Ginsburg at Georgetown Law School in the 1990s, husband of Ruth Bader Ginsburg, who everyone knows. But Martin Ginsburg was a famous tax lawyer in his own right. And he said, quote, I'll talk to you all day long. If you want advice from me, you have to sign my engagement letter and pay my retainer. So no one signed the engagement. I'll provide the live information to Alan here, okay? To address the question, I'll address the question. So to address the question here, it goes like this. I mean, here, there's an immigration law aspect to this. And the immigration law aspect is the fact that if you know you're a US citizen, you cannot enter into the United States on a foreign passport. You've got to enter the US on a US passport. Okay, so if they're advised by immigration counsel, they're going to say, do not enter the United States on your Japanese passport. Okay, you can't do that. You're going to have to get a US passport. Now, the question comes, and I hear this often, if I get a US passport, am I going to be subject to US tax? Well, it doesn't make a difference. Those days are gone. Okay, once you became a U.S. citizen, presumably at birth, you're a U.S. citizen for tax purposes. And so, I mean, here these other questions are this type of question, and Alan's asking this question in good faith. But often the question is, what can I do to fly under the radar to not be discovered? Now, that's not Alan's question, but I do get a version of that question here. Well, gee, will I be found out if I apply for a passport? And the answer to that is perhaps, by the way, because there is a loss of passport if you haven't paid your taxes and you haven't filed your returns and are tax compliance here. I mean, there is a potential of getting a letter, and that's being enforced by the IRS here on that topic. Not really, I don't see that much of it here, and it's not really that big a business for me, because my clients are in compliance, but I mean, the potential is there. And so, I mean, issues like, if I don't register the birth, that means my client's not a US citizen. Wrong. Client's a US citizen, okay, here. And so all these things that require, and it's an easy thing to remember. The easy way to remember is going back to what I mentioned at the beginning of the program. And that's the Supreme Court case from 78. That states that you have to affirmatively, the citizenship is a matter of right. It's endowed to you. Okay, so you have to affirmatively give it up. And how would you give that up? Well, I mean, most of the time it's a renunciation. Sometimes it's taking an oath of allegiance to another country with the intent to give it up here. And in very rare cases, as we've seen with other countries, it's taking up arms against the US. And I mean, we see it more in the case of Britain, for example. We've seen a few issues with loss of citizenship with Britain, and our colleague, our mutual colleague who introduced us, knows that issue quite well.
Well, and it sounds to me like if you're anticipating, if you think there's an issue, engage Clayton Cartwright and get them together. Now let me go on. Another friend of mine, Roger Epstein, a Hawaii tax attorney, asks, what are the reporting responsibilities and obligations of employers and immigrant employees with respect to notifying the IRS and filing W-2s and 1099s? I guess who's responsible is his question.
Well, I mean, there's always the issue of withholding agent liability. And so an employer or a service recipient, employer in the case of an employment situation, a service recipient in the case of a true independent contractor situation. Okay, those two. And so there you've got the issue of withholding agent liability. It's why when anybody who starts a new job, they fill out a W-4. Most of our audience here, U.S. audience, knows a W-4 that's there. And so on that W-4, the individual has to fill out the requisite information, including a social security number there. Okay. And usually that's the case. Now, when it comes to new workers in the United States, let's assume that the visa has been issued. Okay. Sometimes the social security number lags. Okay. And so the withholding the fact that you don't have a social security number but have a valid work visa doesn't prohibit you from working. Okay, it's just a social security number. You've got the employment authorization document. You're just waiting on the social security number. Payroll systems can adjust to that issue here. And I work with corporate clients and advise on that issue. So that doesn't stop you here. Okay, but the onus goes back to the employer. And so if somebody fills out and gives a fake social security number, and claims 10 exemption or whatever, a number of exemptions that aren't there, if the employer has acted in good faith here and they have no reason to know, then there's not going to be really any issue that comes back and hits the employer, based upon that. Now, a practice just ended in the U.S. called the no match letter. And so Social Security Administration used to send employers no match letters here when the Social Security number didn't match up with the and sometimes that was just a data error here, generally deemed to be a victory by the immigration bar here, because there were a lot of compliance issues with those no match letters. So anything that the employer knew that was there could come back and impute liability back to the employee. Impute liability back to the employer when it comes to these issues.
Okay, so it sounds like the employer's got some responsibility. Now, I want to go to the next question from Glenn Melchinger, another Hawaii lawyer. Glenn asks, what has been the legacy of taxigration under the former administration, and where is it going under Biden administration?
So this is a great, I really like this question because it allows me to say something here, and that is when I joined, I was in my first job. I worked as a CPA in the early 90s, and then caught religion and went to law school in 1993. But I was in a government agency from 90 to 95, and I was hatched. I was subject to the old Hatch Act. Okay, the one that prohibited me from even engaging in local political activity, the old Hatch Act here. And so I proudly can say I have been apolitical since 1990. And dare I say, I want to say I'm transpolitical. I'm beyond politics here. And so my point is that I understand this is a politically charged question, but I'm going to give a policy-based answer here, okay? I'm neither Republican nor Democrat. And so at the former administration, you would think that the former administration, which was seen as anti-immigration, would attack the immigration system through the tax code. And we really didn't see that, with one exception, and that is one offshore voluntary disclosure program was initially eliminated and eventually consolidated into another one here. I'm not saying that the former administration was easy on taxigration here. I just was expecting the boom to be lowered on lots of practices here that really haven't been enforced, that have been on the books for the better part of 50 years. And so conversely, with the current administration, you're seeing a big emphasis and a ramp up in tax enforcement. Okay, when it comes to this, you're seeing calls for additional funding from the current administration. And so I almost feel like it's almost like the Clayton Cartwright Full Employment Act between the two administrations that are here. Because they're scared. On the prior administration, I have received clients because they're scared about what's happening with the enforcement of the immigration of the INA. And now I'm receiving clients now because of they're fearful of the tax proposals that are coming from the current administration. Okay, here. And so it's a
very interesting.
It's contrarian.
Now, look, we have one more question and just a couple minutes left. Lawrence Foster, former dean of the University of Hawaii Law School, worked a lot in China. And he asks, he says, many expats working in China are from countries that have tax laws whereby their citizens are not double taxed. But the US is not like that. Apparently, you could be double taxed, I think is what he's saying. Is that going to change? Or where do you see that going?
So I think that goes to a provision of US tax treaties, income tax treaties. And we have a large network of income tax treaties, second only to the United Kingdom, I believe, when it comes to our network of tax treaties. That the United Kingdom is because of its relationship, I think, with the Commonwealth. But the aspect is that we have a savings clause. Okay, remember when at the beginning of the conversation, I said the United States is unique about its citizenship-based taxation system. Okay, and so that means that US citizens can't go abroad and say, I am resident in China for tax purposes, not in the United States. Okay, and therefore only tax me on my US source income. You can't do that. And so that citizenship-based taxation, the aspect of that in tax treaties, is based upon two words: Pax Americana. The United States is the largest economy in the world, and when it comes to tax treaty negotiations here, carries heavy weight. And so, perhaps when we look down the line in 40, 50 years here, I mean, I'm a patriotic American, but I think I have some foresight here that we'll be an upstanding player of the world. We may be the third or fourth largest economy in the world here, and we may not be able to maintain that when it comes to tax treaty negotiations, perhaps. And so that's where I see it happening. I don't see it happening now. I see it happening when the US's economy is not as big of a player on the world stage, and perhaps we'll see some reform that comes there, and maybe a revision and a revamping. I mean, I think it's going to have to happen constitutionally in the United States of our citizenship-based tax system. The issue there is that citizens abroad have the right to vote, and maybe they've voted in this past election in increasing numbers, but they tend not to. And so, in the words of Marty Ginsburg again, when you're looking for a revenue raiser here, when you're providing tax relief, the anecdote was where you hit. You hit the people who don't vote, or the people who are like not residents here, because they don't have the lobby. Okay, and so. And I hope, Professor Ginsburg, you're 10 years gone from us. I hope I quoted you right on that one. But I mean, I think that's the general rule. And so I don't see a groundswell here. Okay, it may be more of a groundswell when it comes in our bilateral economic relations with other countries, where we just can't maintain that position from a treaty perspective anymore. Okay,
we have 1 minute left. Okay. And a lot of the things that you said, and we could talk for hours on this topic. I mean, there's just so deep, and just the basics are deep. But, a lot of what you say seems to lead to the conclusion that maybe being an American subject to tax is not always good. And you talked about renunciation of citizenship. Where do you, in the 1 minute we have left, where do you see that going?
Well, I think there is press about the increasing number of renunciations in the United States and how they're increasing every year. So audience know this. The press is wrong on this. And what I mean by that is that the numbers, there's probably approximately 1,000 Americans who give up their citizenship each year. The numbers that we see reported quarterly by the IRS include something called abandonments of long-term lawful permanent residents. Okay, and those numbers are going up. Okay, but the renunciations are staying kind of flat here, the way I'm seeing it right now. And frankly, the numbers that are reporting for 2020, that occurred in 2020, the consulates and embassies were closed for a good chunk of 2020 for renunciations. And so we know that we've got a data lag on those numbers here, but yet the press still reports that renunciations went up again in 2020. Well, they didn't because the consulates were generally closed. I mean, the DOS, Department of State, considers renunciations to be probably one of the lowest priorities. Here it's 1,000 people, and so if they're having American citizen services in the consulate, they're focusing on COVID relief, making sure their citizens are protected abroad. They're not looking at renunciation. I mean, that's when they're looking at their priority list. Now, I don't have inside knowledge to the Department of State, but certainly, I mean, that's the press that I see that's coming out, and the flavor I'm getting here is that we're just not going to give this a priority until the pandemic's behind us. But saying that, one thing I will mention to the audience here is that, and one thing that immigration lawyers and I counsel is that if someone does make the decision to renounce their citizenship, okay, one, they better have another citizenship. Now, that's not the law. You technically can renounce and be stateless, but practically it's impossible to do so at a U.S. embassy or consulate. Two, you better not walk in there and say, I'm doing this to cut out my U.S. tax liability to save taxes, because that could bar, under something called the Reed Amendment from 1996, that could bar entry into the United States afterward. It's rarely invoked, but you don't walk in with bullhorn saying, I'm doing this for tax reasons. I mean, that is king stupid, as we would say when I was in DC. It's the most royal of stupids, okay, imperial stupid, okay, to do something like that. Now, it's okay to say I don't want to pay Cartwright's fees here, and I don't want to pay my tax account, my tax lawyer. That's okay. That's not for tax purposes. That's just not paying. You just don't want to deal with the transactional costs, okay? But really, you don't even want them to mention the word tax. No mention of the T word when they go in and renounce.
All right. Well, Clayton, I appreciate you talking with us today from Georgia. It must be getting on late at night, and it's midday here. And so I want to thank you very much. You've touched on a topic that we need to really, a lot of our international lawyers need to know a little bit more about. So as we say in Hawaii, mahalo and aloha.
Mahalo and aloha.